Welcome back to Winning Isn't Easy. You know, I read the cases that come out across the United States, and I learn a lot of things from those cases. I learn how disability carriers handle claims, how the experts that they use, the rationale they come up with claims denials, and how courts deal with these claims. Unfortunately, sometimes these court cases can read like horror stories, and I'm going to tell you two horror stories today that illustrate the points we've made about how disability carriers evaluate a diabetes claim. And I think that this reinforces the theme that we've discussed today about how carriers will evaluate claims and they don't always appreciate restrictions and limitations. So let me tell you about Mr. Kosmanoff. He was a sales representative disabled by diabetes, and his hopes were dashed by the court. Now, sales representatives work long hours. They prepare and make sales presentations. They travel locally and across the country and even across the world. But what happens when a sales representative has diabetes that's aggravated by the physical demands of their duties? It's crucial that the claim be supported by medical evidence that establishes the objective basis of the restrictions and limitations, the risk of further injury or acceleration of a disabling medical condition, and even the risk of death. Simply saying that you have those kinds of issues doesn't make it so. And that's what happened to Mr. Kosmanoff in his claim against Unum. Now, he worked for Thomas Reuters and became disabled as a result of diabetes. He claimed that he was entitled to his benefits because performing his duties involved a high risk of injury or mortality due to his inability to control his blood sugars. He worked as much as 18 hours a day as he traveled across the United States. Of course, his claim was denied, and he appealed the Unum denial. The bad news is that the court upheld the denial of the benefits on the basis that the records did not support a functional loss. And the court also noted that his employer had made an offer of accommodated work, which was refused. Now, in retrospect, what he should have done was have his doctors address accommodations and submit any proposed accommodations to his employer, try the accommodated work, and if he failed at that, have his doctors address in objective medical terms why it failed. The doctor should have also addressed the impact of the of working and how it contributed to the progression of his disease and potentially was life-threatening. So the key here is to read the policy cover to cover and learn whether objective proof is required, whether that is defined, determine whether there's any accommodation provisions in the policy, and then plan for how you're going to make this argument that the accommodations either aren't feasible or if there are accommodations that they weren't successful, and how your occupational duties result in a progression of the symptoms or even threaten your life. Obviously, this is going to require a review of your medical records, but more importantly, in my view, it's going to require coordination with an experienced ERISA disability attorney. Now, let me tell you the story about the First Circuit. And they're a tough circuit. They generally will seldom stray from upholding a disability carrier's requirement that there be objective medical evidence of disability. And you can hear this theme. While there isn't a uniform disability policy in the United States, every carrier has got multiple versions of their policies, but rarely do I find that these policies will give you a free pass on objective medical evidence. Now, I know that your employer, your human resources department, probably never told you that you had to have objective evidence of disability or objective evidence of restrictions and limitations. And that's bad news for you because you bought something thinking it was going to cover you and you didn't really understand what it is you had to prove. Now, the other issue also in these policies is whether there is what's called a subjective medical condition. And many policies will have a laundry list of conditions that are not considered to be objectively based, like fibromyalgia or pain or tingling or numbness. So let me tell you the story of Mr. Santana Diaz. He was insured through a plan administered by MetLife, and MetLife paid him 2 years of benefits under the mental nervous limitations. Now, he had diabetes and had diabetic neuropathy to his hands and feet that caused tingling and numbness. The MetLife policy required that he submit objective medical evidence of clinical findings of the nerve pathology to continue payment of his benefits beyond 2 years, like the case that I told you about where the policyholder had to have an EMG and nerve conduction study test to document his diabetic neuropathy. And unfortunately, Mr. Santana Diaz did not have that objective evidence, and as a result, MetLife denied his claim. This policy gave MetLife the discretion to interpret the term objective medical evidence and to determine whether there was any such evidence in the claims file. The First Circuit said, look, the policy gives MetLife this discretion, and we're going to defer to MetLife in determining whether there was any objective medical evidence to support the continued disability benefits. Unfortunately for him, his claim denial was upheld. And you can see in both of these cases that notwithstanding the diabetes and the complications, carriers are going to insist on objective evidence of the diagnosis and objective evidence of the restrictions and limitations. Hopefully this episode has opened your eyes to the kind of proof that needs to be submitted to support any disability claim. Well, that's it for this episode. If you like this podcast, please like this page, leave a review, and please share it with your friends and family. Our podcast comes out weekly, so stay tuned, and I look forward to talking with you next week. Take care.